may
What
also
I understand while listening to all the intellectuals, the problem we faced because of the problem in the judiciary system and the policy. And what could be the probable solution? That is the main things for the today.
no. That problem is a given. It will always be there. With that problem, what we can do?
Yes.
प्रॉब्लम को वो प्रॉब्लम मैक्रो प्रॉब्लम जाएगी ना
What will be the
इसलिए ऐसे
problem?
आइडिया क्या है
So I am taking the one example. But today, basically the infrastructures and roadways companies are facing after Operation Sindhu. There was a circular in 2022. The countries which are sharing land border with the India shall have to take the security clearance from the Home Ministry before entering and appointing the hacker in India and taking any business from the India. Taking the clue of that circular. Now after Operation Sindhu, the company, suppose the US company is registered in US, control and owned from India, doing business in infrastructure in NHI. Government is asking, after qualifying the tender, take the security clearance from the Ministry of Home Affairs and submit it within 7 days. Now, this is the policy problem. And this policy problem, what will happen? I am facing this problem. I am planning to approach Mr. Das to make a mandamus writ petition to file to the Supreme Court or High Court to get the solution. Because of the policy problem, judicial burden are increasing. What could be the solution? Solution just like this. Why not we should create a think tank of the intellectual which will make a literature or draft paper, go to the government or the policy maker or the judiciary, wherever it could be approached, and say that if these are the actual problem and these are the probable solution, and we could be the intellectual assets for you, give this task to us and we will give you the solution. So these things, if you will start, then I think
I'll give a solution to it in exchange of one request that the problem which
I am coming to the point.
what
Now.
can we do?
Now I am coming to the point. Especially as of the day, 28 lakh 17,000 private limited companies are in India, and 65% companies incorporated only for this purpose. What the family is facing. What happening? Especially in Noida and Delhi area. I am purchasing a property. If I will purchase property from Mr. Misra, then I will have to give the stamp duty and registration fees. If Mr. Misra has a private limited company, and that company on that property, I don't have to go to the sub-registrar office. I simply have to buy the shares of the Mr. Misra's private limited company. And this is happening. And that
Kind
is
of a laundering.
Huh?
Kind of a laundering actually. It's a money laundering.
But you cannot prove it.
and
But you cannot prove it.
No, you cannot disprove it. Money laundering is automatic. Disprove is impossible because of the section 24.
And nothing.
That ED doesn't know this power. You get to know in few days.
so what the legislator come with the solution of this kind of problem, especially in Noida. Noida authority come with the circular two years before. They are creating a concept of CSE, change in constitution. If you are transferring your company, by transferring the shareholding, where the share is a immovable property, as you told, it can be transferred by simply execution of the deed. It is not required to get transferred. If you are changing the constitution in the company, and that constitution change more than 50% of shareholding, then you must have to come to register the CSE, change in constitution deed, and you must have to give the stamp duty and the registration fees also. But what happened if it has already been happened 10 years, 5 years before, or law come into the knowledge? I think this happened with the bank case or some other case.
Limitation can knock off.
Limitation.
Can be knocked off. Section
See,
1422.
that is something else. But thing is that there is a difference. Document showing the title and document of title. What share certificate is? share certificate is document showing the title. It is not a document of title. That if you will be able to prove in the MAN case, if the share has been transferred simply filing as a from as a 7 or share transfer from green clerk or from sign ho gaya hai, and because of that the share got transferred. So where is the execution document document showing the title? And I am facing a lot of the cases in the NCLT also management and operational mismanagement cases. And what is happening, as you told, because of the IBC problem, I have filed a case in 2019, operational mismanagement case. 22 hearing, 22 times the case come into the before the bench, and 11 times positive of time.
Positive.
And 6 times both advocates not appears, and 3 times some little bit hearing happened. What happened at the 1st of the July? Bench said, actually this is a very old case. Let's have the fresh notice to the party. So this is the system. I mean, this.
So therefore suggestion.
Therefore
Suggestion is, like for example, her problem, according to me, we must need to resonate beyond the court. Court पे तो कर ही रहे, हम कर रहे हैं या करते रहेंगे. But the point is there is a paucity of time. That's again you resonated, and this is a problem across all the lawyers. And in fact, I'm telling you, unlike you said that the lawyers will lose the job, I always say that the lawyers in any case is losing the job. People see, a client can't stay with you for 5 years by paying a hefty sum of money. I mean, there is a limitation, correct? This is criminal on the part of the lawyers or any of us if we are stretching beyond a 1 year time of a matter. Now the question is, but the system is not is there. How do we do that? So what are the ways? Like for example, as I suggested, मेरे सबसे request है review को मैं तो कर ही रहा हूँ, आप लोग भी review करिए. That is called the distillation approach. आपके जब भी litigation होगा कहीं पर भी आपके lawyer को पूछते हैं. Distillation method is the only way by which you can redress this problem. You go to the same judge, tell him that ABC is the error. This is the error I am showing you. You correct it. And very recently, Supreme Court has also come with a little departure from the old jurisprudence in the review, saying that if grounds raised but not adjudicated, that can be a ground of review. In other words, it supports by theory.
But you have to reach that stage.
Not reach test.